The necessity defense is similar but a little bit different from the self-defense or defense of others claim in Massachusetts. Necessity requires the defendant to show that there was no reasonable alternative but to commit the crime that they committed. Often requires an admission by the defendant that yes, this did happen, but it only happened because the alternative would have caused more substantial harm. There wouldn't have been a reasonable alternative to try to dissipate that harm and also avoid the conduct that I did. So if that's raised at trial, the prosecutor then has to prove beyond a reasonable doubt either that there was no substantial harm that the defendant faced, or that there was another reasonable alternative that did not require the defendant to commit a crime that could have minimized or dissipated that substantial harm. So I'll give you an example of a case that I had that was successful, we went to trial on, and how the defense of necessity could apply. So I had a client who was borrowing an on-again, off-again girlfriend's car. While he had that car, he was also courting another girl. So he was with another girl in the car, and then the on-again, off-again girlfriend found out. So she went to stake out the boyfriend-ish and his new girl. And so she confronted them while the guy and his new girl got into the old girlfriend's car. And then she comes up and approaches them. She revoked her consent for the defendant to have the car, so that was a crime that he would operate the car without her consent. She tried to get in. Instead of letting her in, he drove off, and she was trying to hold on to the door, opening the door, and she ended up getting dragged, and she was left there, so there was leaving the scene of a personal injury. There was, ultimately there was about 5 charges altogether that my client faced. Now, his defense was that, yes, everything that was described happened. Yes, I probably should have made it clear to my old girlfriend that we weren't together and that I was interested in other girls, but that's not a crime. And so he really took it upon himself and decided with my help that he wanted to testify, that we wanted to go to trial. Went all the way to trial, and he testified very eloquently, and he explained that, you know what, I was in the wrong, morally maybe. I should have taken her feelings into account, and that everything she said was true, but that I didn't know she was going to hold on to the car, and that she wasn't so eloquent when she came to me and asked for the keys back. In fact, she was pounding on the window, she was screaming. In fact, she testified for the prosecution, and on cross-examination, she admitted that she was screaming and yelling and out of control, and that she had subsequently sent a message to somebody else that we got a hold of that said, I would have killed them had I opened the door. So we were able to present that at trial, and essentially painting the picture that even with her own admission, she was so enraged that she would have attacked the client, and that he did what he had to do, meaning he pulled away. He didn't report her being hurt because he didn't know she was being dragged, but he did pull away. He didn't give her car back because in that moment, at that time, the only alternative he would have had would be to open the door or to wait and try to call the police, but if he did that, she might have broken the window. So essentially, there really was a substantial risk of harm to himself and also to the other girl he was with, and that there was no other way for him to dissipate the harm without just getting out of the situation. So he pulled out. He didn't pull out too fast. He went down the road a while, went a few blocks, and then ultimately took care of what he had to do, and I think the police were called pretty shortly after. So the jury came back. They found him not guilty on all 5 counts, even though he basically admitted to having committed all crimes. But he was excused because the judge instructed them on the defense of necessity.